This is our second lesson in the topic of the repudiation doctrine. So if you haven't already, go back and watch the first video where I talk about the doctrine of repudiation. In this video, I'm going to very briefly review it and then apply it to a case where repudiation may or may not have occurred. Repudiation is a refusal to perform before the time for performance is due, and it has the effect of a total breach. And we saw that is found in Restatement Section 250. Part A deals with statements. The statements have to be unequivocal. And Part B deals with acts, and the acts have to be voluntary and affirmative. So how does this play out in a particular case? Well, let's talk about the case of McCloskey versus Minweld Steel. Oh, hi. Guess who wants to learn about contracts? Okay. Hi. Say hi to everybody. So everything's better with a dog on your lap, right? Even when he's 10 times the size of your lap. So in this case, we have a question as to whether or not a statement was sufficient to create the type of doubts or the type of unequivocal refusal to perform. And we'll find punchline, spoiler alert, the answer was no. The answer was no, we did not find this letter was sufficient to cause a repudiation, but it was sufficient to provide doubts and to allow for reasonable assurances. So it's in that gray area that we're really trying to focus on for this week. So this was a contract to furnish and erect structural steel on a hospital building, actually, in Hollidaysburg, Pennsylvania. And you'll really, I think, tune into this case, right? The fact that the hospital turns out to be somewhat relevant to the facts. As you might imagine, this job required steel. The job to build a steel frame, you need steel. I'm not an expert on metallurgy, but I got that far. The problem is that it's hard to get steel because of something that happened in the world. War broke out. War in North Korea. So North Korea invaded South Korea. President Truman sent over U.S. forces, and by presidential fiat, really bought up or froze a lot of the materials for steel. I mean, something similar, again, is happening right now. I mean, what if this was a hospital contract, and instead of the contract being for steel, it was for ventilators? Can you see how hard it would be to get ventilators into that hospital now, right? So we could have facts like that, which are occurring because of a different type of catastrophe. And we also have a strike from the steelworkers. So, I mean, hopefully this doesn't happen to us. This is actually a photo from Pittsburgh. 1952, this is Pittsburgh Steel striking. And this obviously compounded the steel shortage in America. Now, the key things to note here, these are what we'll later refer to in excuse as things that amount to acts of God. Although war are acts of men, but in a sense, we have these huge, it's just the term of art, we have these actions that are really outside of the party's control to a great extent. We've got a war and a strike, and this really has nothing to do with McCloskey or Minweld. So in terms of our 250B analysis, we're clearly not at a level where there was an affirmative voluntary act. And so we're not even going to look at that. We're going to look at whether there was a statement made that constituted a unequivocal repudiation. Here's the meat of the letter. This was sent on June 20th, June 24th. In view of the directive from Washington and the tightening up of the entire steel industry, we solicit your help and that of the general state authority in aiding us to obtain the steel for these contracts. All right, so let's pause on these words here. Right? What's the standard? In order for this to be a repudiation, these words have to be a clear and unequivocal refusal to perform before the time performance is due. So what are some thoughts here? What is this letter saying? Is it saying that there is no way, hell or high water, that I'm going to build you that building? Or is it saying something else or something less? Well, I don't see anything here that says that they don't want to perform, right? They're actually looking forward to performance. We are as anxious as you are that there be no delay, but we have nowhere else to turn at the present time for supply of steel. And remember when I mentioned this was a hospital? Hospitals are priorities. Hospitals are priority construction projects in wartime. So the company here is saying, we're just some little steel company in Hollidaysburg, Pennsylvania. You're a big time hospital manufacturer. You have connections with the governor and the mayor and maybe the president. Maybe you can pull the strings necessary to keep this project going and get us steel in a world and a time when others don't have it. And that's exactly how the court found this to come out. So, I'm just going to kind of move quickly through the procedural posture, but effectively, the case was finally held that this letter did not breach the contract. This was not a repudiation, also called a renunciation. Why? A renunciation is an absolute and unequivocal refusal to perform or a distinct and positive statement of an inability to do so. And that's not what this letter says. This letter, and this is quoting from the judicial opinion, does not state that Minweld had definitively abandoned all hope or of otherwise receiving the steel, nor does it state that Minweld will be unable to perform. That's what it would have to say. It'd have to say, there is no hope. I can't get steel. It's just not going to happen. I'm not performing. Rather, they said, we want to perform. We just need some help. Do you have another source? And then what happens next? And this is the common fact pattern. And I believe this was, I'm sorry, I saw a question at the very beginning of class I didn't get to. Let me scroll back up relating to this about whether the other party is allowed to terminate. So basically, McCloskey terminated the contract improperly. Right? So Minweld says, I'm having some trouble getting steel. You might have noticed the war and the strike by the steel workers. So it's not so easy these days, but you really could help us out. How does McCloskey respond? McCloskey says the contract is terminated and they found someone else. So this is a common situation. When McCloskey was mistaken. McCloskey mistakenly thought it had the right to terminate the contract. It didn't. So McCloskey was the party that breached. McCloskey breached by terminating the contract before it was proper to do so, right? And it was not allowed to cancel the contract at this point. So the question I received at the beginning is, how should an attorney counsel, a party in a situation like this? If you are, look, this could be you. If you were 4 years from now, or 4 years older now, you'd be out in practice. You'd be in your first or second year of practice, and right now, there are people that are saying things like this. It's COVID-19. I got a letter like this. I've told you I moved. My other house is up for sale. The buyer is supposed to inspect the house by 14 days. And I got a letter from them saying, we're not sure that we can hire an inspector. We don't know that any inspectors are currently doing home inspections. Now, what are my rights? Now, for one thing, I don't want to cancel the deal because what am I going to do? Who's going to buy the house now? So, but even like this, how would you advise me? Do I have the right to terminate? The answer is no. There's still doubt. They're expressing doubt, and the parties are meant to work together in good faith. So as a practice point, especially in times of crisis, courts are not going to be friendly to parties that kind of take the advantage of ditching a contract party at the first sign of weakness. This is a relationship now. You're in a relationship with your contract party. And so I think erring on the side of caution is helpful. On the other hand, you could ask your client, well, what does it really cost you to wait? How are you being harmed? How much is it really going to affect you if you give them some cure period? If in fact the harm from delay is very high, that might counsel you to determine that total breach is more likely, and therefore this does amount to a repudiation. And here's the problem. The lawyer is going to be thinking about, how do I avoid my client getting sued for this later? Meaning they're going to be more prudent. And meanwhile, the business person is saying, I'm losing money today. And so you'll have some tension with your client, because most likely the client will feel more comfortable canceling and saying, I'll take my legal chances later than the lawyer who doesn't want to take the legal risk. But can you see how this would play out? Right? I mean, how would you answer this in a situation which, you know, and literally, I mean, I might be faced with it. It might be the case that the contract says they're supposed to close on the house on May 14th. On May 14th, they might say to me, or May 13th or May 10th, they might say to me, I'm not sure the bank's going to be ready to close. What are my rights? Well, it's a tricky issue, and you have to do all this work you're doing of the semester, putting on both sides, making your best analysis of the argument, and guesstimating without the benefit of an opinion what a court would do in a situation like this. And of course, that is a difficult analysis. We do have a tool to help with that analysis because the restatement makes it clear that the repudiation needs to arise to a level of total breach. So if we're really not sure and we're looking for something formal to try to apply our thinking, we can use the 241 and 242 factor test and determine if the action would constitute a total breach, we are more likely to find it was also a repudiation. So things like if I'm harmed by the delay, so take an example again about the house. So what if it delays from the 14th to the 15th? I'm not selling that house to anybody else. They're not even showing houses right now. So it's unlikely to say that's a repudiation because I have very little harm from delay. And that's just one example of how we can use the 241 and 242 factors to try to get a better analysis of whether there has been a repudiation. All right, so some concluding thoughts, then I'll take some questions. So the exercise here is really putting yourself in the position of a practicing attorney. In this case, the attorney for McCloskey. You get this letter from Minweld, and your client says, well, I want to cancel the deal. You have to determine whether they can or cannot. And you have some factors, 7, in fact, the 5 from 241 plus the additional 2 from 242 that you can weigh and balance to make this decision. The contract said time is of the essence. That suggests that repudiation is more likely. On the other hand, the statement is not unequivocal. And it's not clear that, you know, there's really a delay because there might not be anybody else selling steel right now. Then put yourself in the position of the counsel for Minweld. Does Minweld have an implied duty to cooperate? Well, yeah, these parties have obligations to each other. They're in a contractual relationship. What does Minweld actually do? And this is why, and by the way, I think this is the bottom line, why Minweld really lost big on this one. Minweld canceled the contract and immediately found somebody else for cheaper. Those are some pretty bad facts. Those are some pretty bad facts that make it look like they weren't trying to work things out, but they were taking advantage of a situation, taking advantage of a market downturn, right? Which is a type of bad faith. Bad faith is a big part of our factor analysis here. And by potentially engaging in a bad faith failure to cooperate, they caused the other party's breach in order to get a cheaper price from somebody else. And we're kind of in this realm of equity here. And so courts are going to be very hesitant to award the benefits of the bargain to a party that's acting in bad faith.